Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. The path toward trial. What's happened? What's still to happen in Idaho versus Kohberger? To address that question, we need to refer back to what I call the blueprint of the case, the October 9th, 2024 redacted order governing further criminal proceedings and notice of trial setting, aka the pretrial and trial order that was rendered by Judge Stephen J. Hippler. What's been done? What's yet to occur? This order will tell us exactly that. You can find it by following the link that I have provided here to you. Go to the Idaho Cases of Judicial Interest, go down to State of Idaho versus Brian C. Kohberger. Click the link for the 2024 filings and then go down to October 9th and look for this document. Click on it, it will pull it up for you. It's a 5-page order. Most of the information that we need is contained on the first 3. Let's get down to it. Page number 1. It is hereby ordered as follows. Any prior scheduling order is hereby vacated, and the following schedule will govern the pretrial matters outlined herein and the trial in this case. Regarding this first sentence, there was a prior trial order in place. It was rendered by the prior jurist, Judge John Judge, when the matter was still in Latah County. That order is vacated. It is deemed null and void and replaced with this order of Judge Stephen Hippler for Ada County. What is the schedule? What's the blueprint for the rest of the case? Well, everything leads up to these items that you see here on page 1. First, the jury questionnaires. This is the only portion of this entire order that's redacted. The date that the jury questionnaires will be administered will be passed out by an administrator from the court to the potential jury members for them to fill out, to be collected, and then to be used at Voir Dire. And we're going to talk about the jury questionnaires in just a moment when we get to that section of this court order. Number 2, those jury questionnaires are going to be used for Voir Dire. This is the process of jury selection. This will commence July 30th, 2025 at 9 a.m. This is when the state and the defense, through their attorneys, will ask questions of specific potential jury members using the completed questionnaires as a tool to help them determine if they want to green light a prospective jury member or strike him or her. The jury trial shall commence August 11th, 2025 and run through November 7th, 2025, inclusive of the penalty phase if necessary. What does this mean? The case in chief, also known and discussed in this order elsewhere as the guilt phase. That's when the prosecutor will get up, will address the jury members with his opening statement, and I'm projecting it will be William Thompson because he is the lead prosecutor from Latah County, which is where the crimes occurred. Mr. Kohberger, who was presumed innocent at all stages of these proceedings, until or unless he is adjudicated guilty by this future jury at the case in chief, is accused of 5 first-degree felonies, and the punishment, capital punishment, is on the table, the ultimate punishment. And what this talks about here, the penalty phase, if necessary, that is only if that future jury returns a guilty verdict. Then matters move into the penalty phase, and the issue on the table is what is the appropriate sentence. Bottom line, that's what the penalty phase is for. There's further details here regarding what the court's expectations are, regarding the parties being ready to go with their witnesses, and also stating what the hours that court will be in session Monday through Friday, and there may be a situation where court may be adjourned for a particular day if, for instance, Judge Hippler is called away to deal with a pressing issue. The bottom of the page, we see a paragraph, the bulleted item, a final pretrial conference. This is when the parties come before the court and they will discuss if there's any issues in the world that could prevent the orderly progression of this trial as set forth above in Voir Dire. This will be held on May 15th, 2025 at 9 o'clock and continue on May 16th, 2025 if necessary. The court here also says that earlier status conference regarding pretrial matters may be requested of the court. The state or the defense could make that request, or the court of his own initiative may initiate an earlier pretrial conference if he feels it's required. Going on to page 2. You see under the section entitled Motions, most of the issues here have already been accomplished. The DP motions that were filed by the defense were all denied. There were hearings that were held in November, and the court came back and denied all of the motions. There are, however, a couple of issues in motions in limine, which the parties are right now in the middle of the briefing section, that raises issues regarding whether the DP should be stricken. We'll get to those in just a moment. Before, though, discovery motions, last day to file motions to compel regarding any known unresolved issues was back on November 14th, and there were hearings regarding the same. The next, the ICR motions, including the motions to suppress evidence. All of the briefings are in. Those hearings happened, and again, the defense's motions to suppress, like the motions to strike the DP, were all denied by Judge Stephen J. Hippler. Finally, we are right now in the middle of the briefing schedule for in limine motions. However, this schedule here has been replaced by the schedule that was published by Judge Stephen Hippler on January 31st, 2025, after the parties, by stipulation, asked for a few more days. So everything got moved. This is the scheduling for the motions in limine. Hearings will be held on the 9th, and if necessary, going into the 10th of April, 2025. Next, discovery and expert disclosures. The defendant's discovery deadline was January 9th. That has passed. Experts, listing of experts the parties intended to call at trial. There's two forms of witnesses, ladies and gentlemen. You have lay witnesses, and then you have expert witnesses. Expert witnesses are those individuals that the parties have listed who they believe will help the jury understand something sophisticated, such as DNA evidence in the case. Judge Hippler established that a list of experts the parties intend to call at trial, including a copy of the experts' reports and a copy of the experts' curriculum vitae, it's another word for a resume, where skills, knowledge, and experience of the proposed experts disclosed, shall be disclosed to the other side as follows. And we see the guilt phase experts for the state. That date came and went, December 18th, same with the defendant's guilt phase experts. We go on to the next page, and we see the schedule for the rebuttal, guilt phase, or case-in-chief experts. This would be from the state, and then we go into the penalty phase, the state's penalty phase, in the event there is a second portion of the trial, if there is a conviction, and you see the dates for those items. There's been some issues that the defense has brought forward, alleging that the state has failed to comply with their obligations under this section of the pretrial and trial order, and there is currently a motion in limine addressing this specific matter that the defense has also filed. The next section is D, trial materials. Now, returning to the proposed jury questionnaires, we know from page 1 that the jury questionnaires in final form will be administered to the potential jury members on a date blank in 2025. This section helps narrow that date a little bit. The proposed jury questionnaires from the state and the defense, they're both to be filed under seal by March 24th, 2025. So the public will not see what the state wants on that jury questionnaire, what the defense wants on that jury questionnaire. Objections are due March 31st, 2025. State has received defense's proposed jury questionnaire. Same with the defense. They've received the state's proposed jury questionnaires. Any objections that one side has to all or a part of the proposed jury questionnaires that the opponent has filed due March 31st, 2025. Now, it doesn't say so here, but one would imagine that this will also be filed under seal, because why would the jury questionnaires proposed be filed under seal and then not the objections that talk about the questionnaires? A sealed closed hearing on the proposed jury questionnaires will be held on April 16th, 2025. This closed hearing, and the purpose will be the parties will be before the court to discuss their proposed questionnaires, why they feel they've raised objections to the other side, and then ultimately the court, after this hearing, will have to make a determination as to what that final jury questionnaire will be. That will then go to the court administrator for dissemination and administration to the proposed jury members. Proposed exhibit lists, they are to be exchanged by April 21st, 2025. Copies of the exhibits shall be exchanged that same day. So in other words, the parties are going to do two things. By the 21st of April, they have to file their proposed exhibit list for use at the trial with the court. Then they have to actually exchange their exhibits with each other. Defense has to send state its exhibits, and the state has to send defense its exhibits. And you see that there's labeling requirements here for use at trial. On or before May 14th, we also see here, the parties together shall jointly file a log in a spreadsheet format identifying which exhibits are objected to and the basis for the objection and those to which there is no objection. Finally, we see here guilt phase lay witnesses. Remember, I said just a moment ago, there's two forms of witnesses. You have expert witnesses, then you have lay witnesses. The witnesses for the case in chief that will be called to testify in the guilt phase or the case in chief are people with actual knowledge of matters relevant to the case. People who saw something, who heard something, who know something will get up on that stand, and let's just say it's the state who has called that witness. That witness will then answer questions that the state poses and then will be subject to cross-examination by the defense, and then there may be a re-examination by the state. These are what guilt phase lay witnesses are. Not people who heard something third hand, but people who heard something firsthand and can testify as to their actual knowledge. That brings us to the next page, which is Judge Hippler's signature page, and then finally the certificate of mailing, and that tells us everyone who was served with a copy of this trial order, so everyone's on the same page. They know what's due, when it's due, and they're provided with further details, how to prepare for trial, when trial will be, and other related materials. So this will now conclude this episode of the IndieZoNe. If you have any questions, any comments, please leave them here. And if you haven't already, we'd greatly appreciate your considering subscribing to the channel, because it does help us grow, and we will continue with our commitment to update you as further matters proceed toward trial, which is just now a few months away. This is Kathy. Thank you very much for joining us here today.